Okay, this is case number 20 CR124 or 214 State versus Kara Whitley. Presently have the case assistant prosecutor James. Presently have the defendant's attorney William Brown. And you are Kara Whitley. Alright. The defendant's charged with attempting to assault a police officer and assault a police officer. She was previously found to be not competent to stand trial and was submitted for a court treatment at the Twin Valley Health Center, and pursuant to the for purposes of restoring her competency. And pursuant to statute, the court received a report from Twin Valley dated July 15 from the director Foreman, and that contained a report from Lisa Falk, F-O-U-L-K, psychologist, indicating that, in her opinion, the defendant was now competent to stand trial, and that she understood the nature of objection proceedings, which is her attorney. The report also said that she does suffer from severe mental illness, but she was complying with her medication, and that she appeared to be functioning sufficiently to be found competent to stand trial. Now, do either attorneys wish to present any other evidence on this issue? Mr. James, you have to say.
Nothing to say, Your Honor.
Trial.
No, Your Honor.
All right, well then the court will find that the defendant does appear to have been restored and is now capable of understanding the nature and objectives of these proceedings and able to assist counsel in defense, and is therefore finding the court that she is now competent to stand trial. Now, it is also the recommendation of the Twin Valley that the defendant continue to be in hospitalization as opposed to being held in jail, so that she can continue to be treated to maintain her mental stability. And so therefore will be before the court that the bond will remain the same as previously ordered, but that the defendant will remain hospitalized at Twin Valley during the pendency of this action. Now, I had originally ordered an evaluation for mental status at the time of alleged offense. I do that always when these issues come up, just so that there's something in the record and try to kill two birds with one stone, so to speak, get both of them done at once. In this situation, as is typical, the original evaluators indicated that they could not, that she could not make a decision or make a report on the defendant's alleged mental status at the time of the incident because she was not competent at that time. And so that has not been done. Based on my reading of the report, I was wondering, Mr. Armstrong, if there was any indication she wanted to enter a not guilty reason by insanity plea for the purpose of being able to obtain that report to determine if that's a viable defense.
I'm assuming the court can't go ahead and order that on its own.
I cannot, no. I mean, since she's been restored to competency, originally I could, but since they couldn't do it, the only way I can do it now is if there is such a plea. And again, if the end of the plea and it comes back no, then of course you would be able to proceed, but at least it's in the record for you and your client. So again, that's what we're going to do with that.
I think it is in her best interest to do that as her attorney, but I've also explained it to Karen. She has told me in no uncertain terms that she not want that filed. So I put that on record, but I don't know that it's her decision. I think as an attorney, I can file it if I think it's appropriate. And as the court has indicated, it may or may not go anywhere. It may find that she was perfectly lucid at the time of this alleged offense, but we just simply don't know at this point in time. And I would like to have a report.
Mr. Whitman, let me say this to you. You're charged with a secondary felony, which carry penalties between 2 and 8 years mandatory time, plus an additional half would be tacked onto that by the Department of Corrections, depending upon their decision while you're in prison if you're convicted. Then there's also the fourth degree felony. So you have potentially 12 years of imprisonment could be ordered, could be served. So that's a lot of time. And it seems to be clear that you do have a mental illness. You have had mental illness for some time. That's why you ended up in the hospital. So you could be treated. You now seem to be functioning very well. But I don't know if there's any validity to a possible plea of insanity, Goldenberg's insanity or not. The legal test is that you have to be suffering from mental illness at the time, and it appears that I think this is probably true because it appears from what I've read at least, your illness has been ongoing for some time. And then the second question is whether as a result of that, you were unable to understand the difference between right and wrong at the time of the incident, if you in fact committed the acts that you're alleged to have committed. And if that is the case, that is a defense. And you wouldn't be sentenced to prison. You'd be subject to hospitalization for a period of time, but you would not be sent to prison. So, Mr. Armitage does have an obligation to represent you in the best way that he feels is appropriate and consistent with your best interest. And so, in my judgment, I think he'd be better served for him to enter that plea for you so that we could have the report, and then it'd be able to tell us whether or not there's any possibility in their opinion that is the case. Well, of course, obviously it depends on your conversation with that doctor who will evaluate you. It probably won't be anybody from Valley, probably from the Forensic Center. And then they'll give us an opinion, and if Mr. Armitage says that that's the case, then it could be a defense for you, which would be in your best interest, because it would prevent you from being sent to prison. And if it says that no, you did understand right from wrong at that time, despite your illness, then it's not a defense, and then we're still in the situation we're in now is going to trial to determine whether or not you will be found guilty or not guilty of the charge. So what he's doing is what he thinks is a legal decision is in your best interest. Now, if you want to tell him absolutely not, that's certainly your right, but if you tell him not to do that and prevent him from doing that, if you should be convicted and sent to prison, then another attorney or you couldn't come back to the court and say, well, Armitage didn't do his job, and therefore my conviction was proper, and I want it to be set aside and have another trial. So if I think he should do what he suggested, but it's up to you. And if you tell him no, I just want it on the record here. If you're telling him no, do not pursue that, then because you're competent, you're capable of making your own decisions. That will be respected. But if you tell him no and it comes down the road, like I said, you'll never be able to use that as a claim of ineffective assistance of counsel or improper conviction because of that. You understand that?
Yes.
All right. So, you want to talk with him about some more before that is done? Or?
Yeah, I'd like to see if there's a plea bargain.
I'm sorry?
I'd like to see if there's some sort of plea bargain. Is that possible?
Well, it's possible to answer your question, but again, if you have a defense that's viable, then, it may not get to that point. Because the plea bargain is, you're charged with second-degree felony, which is going to be prison time convicted because of this offensive violence. I don't think it's mandatory, but I can tell you that when I get a second-degree felony of violence, I don't think I've ever not sent somebody to prison. And so, that's a big risk for you. Not because of you, just because, in my judgment as a judge, when somebody commits a second-degree felony, particularly against a police officer, that's a prison term. And even if it's a fourth-degree felony, it's usually a prison term. So, that's something you have to consider. But And that can still happen down the road, once we get this done. It'd take about another 30 days to get that report in. And if it comes back and there's no defense, then you can talk, whether you want to go to trial or see about a plea agreement. If it comes back that it is defense, then that's going to really help you in terms of leverage with the state's position, because, then, there's going to be a question whether they want to proceed and get another doctor to look at you, or, what's going to happen. So, that's where it's from.
If we could, Your Honor, if Mr. Swisher's here, that would take about 2 minutes, and we could do his case, and then I'll
Sure.
speak with
All
Carol.
right, yeah, because I would like to have it on record before we get done today, so she's going to go back and point out.
Okay.
All right, so we'll take a recess, and then we'll do Mr. Swisher's case and talk with her. Okay?
Carrie, you have to leave there.
Case number 21 CR 87, State of Ohio versus Brett R. Swisher. President of the State, Assistant Prosecutor King, President of the Defendant's Attorney Armentrout, or Brett R. Swisher.
Yes, sir.
All right, Mr. Swisher was here yesterday on a pre-trial. He's in the custody of the sheriff, has been brought back from the institution for the hearing yesterday. And there was some discussions going on about the case, and then this morning, Mr. Armentrout and the prosecutor met with me and informed me that he has a conflict, Mr. Swisher, because apparently one of the individuals that they have evidence been involved in this in terms of these transactions is a client of his firm. And so that means that he's not in a situation under the rules of professional conduct to be able to represent you, because a lawyer can't be put in a situation of hurting one client with another or protecting one client with another. So it puts him in a position where it's not, even if you wanted him to stay as your attorney, he's not going to be able to do it under the rules, because it's just too major of a conflict of interest for me as a judge to allow that to happen. And so my understanding is you're will be withdrawn because of that.
I am, and I filed a motion earlier, but
Oh, you did? Oh, okay.
well, I asked him to bring it upstairs, but I don't know if later or not.
Oh, wait a minute, let me look here, this is the red jacket. Oh, I'm sorry, it's here, all right, so, all right. So based on that, the court's going to make him to withdraw, going to vacate the trial date, I forget what it is, but I think it's next month. And I'm going to appoint new counsel for you and set a new date, and I'm going to appoint attorney Catherine Hackner. I was looking at doing some research here, actually, right before to make sure I didn't want someone else who might have a conflict of line to see if she's had any contact with the individual that they told me was involved. And so she'll. Okay. Oh, wait, who was Miss? Mrs. Swisher?
Oh, she's, I guess it's potentially gone at his wife.
That's just what I thought. When he said that, that's what I thought. I was getting ready to check it. So can't be her. So, I know it can't be Mr. Wagner. So I'll appoint attorney against her. So if you would get your file, a copy to give to him, and I'll contact him and inform him and we'll get a copy of the entry. And then we will set this for another pre-trial on August 11th at 1 p.m. And that'll be in person, Mr. Swisher. So, and then we'll set the trial date, which is currently set for. I think that's. It was originally 15th, so we'll kick it back. So we'll move it back to August. Let's see, today's what, the what's going to go, what's going to happen with that after he consults with you. And if he's not able to consult with you before the 18th of, or I mean the 11th of August, he'll be able to do so when you're brought back. All right? Anything further? All right. We'll go ahead and go recess again. I'll everyone until Mr. Travis can. on record in, State of Shakira, Beckman, place you on, you know, for the term about, talk, Mr. Bickman, so what?
Your Honor, as the court's heard, Ms. Bickleman's been hit with quite a bit this morning. I would ask the court to restore to the active docket, set it for a pre-trial maybe in 30 days when she would be ordered to be brought back so I can speak with her again. She's very, well, she's been restored to competency. She understood everything I was saying and actually raised a couple pretty good points that I can't at this moment in time answer for her. But at that time, we would be able to make a decision.
All right, we'll set this for final trial on August 11th, or pre-trial, okay, which one we're on, at 8 a.m., or, I'm sorry, at 1 p.m. And then we'll tentatively set the trial date for August 26th at 8 a.m. And, as I said, and then we return back to Pleas Valley situation treatment. All right. Anything further?
No, thank you, Your Honor.
Thank you.
Please rise.
Your Honor, could Mr. King, myself, see you